assume for a minute your child's in a private placement like Meeting Street, and things are going great, and you're doing what you're supposed to be doing, and the last IEP meeting you had with the district here at Meeting Street, or whatever private placement it was, your child is doing fine, and there's been an agreement that the private placement would continue. And 7 or 8 months go down the road, and you get a letter in the mail from the district saying, we're so happy to announce that we feel your child can come back to the district. And if you're a parent of a special needs child like I am, your heart sinks. Change is never good. We all as parents want that day, but we want it for that child when that child's ready. And the district may want the same thing, but they also may have budgetary constraints that require them to try and pull back. So what do? What is your plan of attack when you're faced with that type of a situation? Well, the good news is legally, you're in a very good position. Because you're already here, you have an agreed upon IEP, and if they want to bring the child back into the district, there's various things they have to do. And a letter saying we'll be picking your child up in September on this bus, we look forward to it, doesn't cut it. Parents have to realize that that letter is meaningless, it's useless, it doesn't do a thing. The federal law and the state law requires that if they want a change of placement for your child, they have to have an IEP meeting. And they have to have an IEP meeting with the IEP team that is currently educating your child. Many districts will already formulate a team that have never met your child. And sometimes in this letter, they'll say, we're more than happy to have an IEP meeting with you. Our IEP team will meet with you on such and such a day, and you go there, and it is people who have never met your child, nor do they know your child, nor have they ever done an evaluation of your child. So your first avenue is to realize that it is the IEP team in the private placement that is the one that makes the decision, which puts that team somewhat in a tough position because they can't always say which way they're going to go. Can the child be educated in the district or not? But if the district pushes it and they want an IEP meeting, which is what you should ask for, say, look, let's have an IEP meeting on this thing with the private placement IEP team. And there's discussion that suggests that the child could be placed back in the district. At that point, you don't agree to anything. You don't sign a new IEP or agree to a new IEP. You don't have to sign a subsequent IEP anymore. What you do is you have a choice at that point. If the district's really going to push it, you can file for due process. Sometimes the district will file for due process if they're really pushing it. But most times they don't. And the reason they don't is this. When due process is filed, the day you file for due process, stay put is kicked in. So the sooner you file for due process, the sooner everything, the status quo remains. And during the course of the due process hearing, and if you lose that, the federal district court, and if you lose that, the First Circuit, during all of those proceedings, which could last up to 4 years, I've had clients where I've just continued losing, but the child remained in the private placement because of stay put. So that's why I say it's an easier way to go when you're in this situation. Because stay put tells you that you're required to agree to, during the course of the litigation, the last agreed upon placement. That last agreed upon placement is the private setting, and therefore the child will stay there during that course. So as attorneys, what do? We just keep going. And districts tend not to like to do that because they've got to pay for an attorney, they've got to pay for the litigation process, and they're still paying for the private placement. So oftentimes due process is required at that point. I'd say more than 50% of the time, the district, after you file for due process, backs off in some fashion. Now, what's been happening probably last year more than ever is that the district will say, we can service the same IEP, but we're going to do it in district. In other words, we don't need a new IEP. We're not looking for a change of placement, trying to get around stay put. We're going to do the exact same things they do here, there. So when that happens, it becomes a little more tricky. You've got to really look at the program that they're seeking to implement. And when I say look at a program, I don't mean go and look at a classroom. Look at the program. Look at the specialized education of the teacher. Look at the amount of OT. Look at the amount of PT, the amount of speech. It's got to mirror what is being done here. And moreover, they can't do it. And if you go to hearing on that issue, they will not be able to do it. So keep that in mind. But that's starting to rear its head. But more often than not, you simply get this letter, and I think the districts oftentimes think that's all they need to do. And these letters clearly violate every aspect of IDEA. They really are changing placement because they say they want to change placement. You certainly can't do that, and the district can't either. So that's the focus on changing from a private placement back to the regular ed setting. Oftentimes, people will talk about this 10 days. The districts will go to this IEP meeting and say, okay, well, you have 10 days to make your decision, then we're just going to implement it. That was never the intent of the regulations. Never. All right? The original 10-day was for an original IEP for younger people. This is not, a change of an IEP for 10 days is not required. If you don't have to do anything within 10 days. The entity that's trying to change the placement, they're the ones that have to do something, all right? And they can file for due process. They rarely do, but they can. So don't be overly concerned with that. So long as you are not agreeing to that new placement, either verbally or in the minutes, or you don't ever say that, I'll think about it, we'll look at it. You don't say no right there either, because it's a brand new placement. You look at the IEP and you call them or email them and say, look, we've looked at this, we don't think it's right, we've decided to stay at Meeting Street. See what their next move is. Whatever their next move is, they can't do it, they can't make any unilateral changes. Even if the majority of the team here says, you know, I think the child might be able to be educated in the district, file for due process. At least there you have stay put. Now, if those folks who say that come in, you may lose at due process, but at least you'll be able to maintain your child in the private placement for as long as the litigation continues. And I think the biggest thing you should come away with this is that you have every right, when you get that letter, that you are not put in a position of, oh my goodness, now what are we going to do? You have far more on your plate than you need, and come with that, that's ridiculous. You get that letter, you call them up, you say, you know, what is this about? But you have rights, and it's actually a fairly good position to be put in. It's a much tougher position to get your child into a private placement that you want than it is for the district to get them out. So, yeah.
How do you get them into a private placement?
I'm sorry?
How would you get a child into a private placement?
Well, I mean, you start as early as you can. And of course, it depends on each and every child, but the districts, you know, depending on what the disability is, the districts, especially in this type of a setting, simply don't have the means by which to educate the child in a public setting. Now, they'll come back and say, oh, it's the least restrictive environment. My son's 23. When my son started here at 2, I was getting that a lot. Meeting Street's changed a lot. It's not like that anymore. In fact, it's more inclusive now than public schools. So they don't have that card to play anymore. So you go, if you have to, you go right to due process. If you start here in early intervention, you got a better shot at it. And once you're in pretty good shape. I mean, some districts will knock at the door frequently, but you can get in at an early age depending on, obviously, the disability. Are there any other questions? Oh, yeah. Yeah, in 2004, Congress put into the act that every due process case will have what they call a resolution hearing. And at the resolution hearing, you try and resolve it. Or you and the other side can agree that you're not going to resolve it and go forward with due process. My general practice is to say I'm not going to go to the resolution meeting unless you have something that keeps the child at the private placement. And if they don't, it's a waste of our time. Why are we doing it? But there is that part of mediation or resolution hearing that you do have to, some people choose to go to. And at that point, on occasion, they will back off. They're going to back down either at that point or when you start due process, they're going to back down. So once the hearing officer determines that stay put was the private placement, the district really is up against the wall. They're going to have to choose either to continue to pay for the litigation, and that decision is usually made right up front, as well as pay for the private placement. So their attempt to save money not only backfired, but now they've got double the costs that they would have otherwise. So, any other questions? Yeah.
So just to clarify, if the district sends a parent letter requesting or saying that they can give your child the same services in their district, and you say, no, I'm going to, you go, you get a meeting, and you request due process, the district is required to pay, or it goes to the resolution, and then it is determined, like, who is required to pay?
Under stay put.
Say that again?
Stay put, which is the federal legislation that requires children to remain in their current last agreed upon educational placement, is paid for by the district. The district under stay put has to pay for it.
So the district will always have to pay for it?
So long as they agreed to the last agreed upon placement, yes.
Okay, but they have to agree to the last.
The previous one, which they would, otherwise the child wouldn't be here,
Okay.
right? So they have got to, you fall back on that last IEP. And if everybody agreed to it, that's where the child's going to stay. But the big thing you have to remember there is that is not, stay put is not triggered until you file for due process. So if you don't file for due process and you don't take any action in terms of doing anything, then at some point in time, the district's going to just say, well, we're going to stop paying. So you gotta take some action in order to trigger due process.
If
Yeah.
you file for mediation or resolution, does stay put go in effect, or is it only if you file for due process?
Once you file the due process paperwork, after that, you are under, since 2004, you're under stay put. Within that, there's a resolution process, but you're still under stay put, yes. And you can agree to continue your hearing for a fair amount of time. Yep.
Does this translate back to a child? My kids have IEPs, and we're in the public school system already. Is it up to the school district to go from school to school? I was in a situation where my daughter was in a K, went to Memphis for kids on the spectrum. She's higher functioning. She outgrew it by the end of first grade, which I was thrilled with. She outgrew the classroom, but I was told we don't have anything for her at this school, and this was our home school. So it was my...
The regs in OSEP, the Office of Special Education, require the child, if at all possible, to be educated in their home school. If they can't be, then yes, they can be moved out, so long as it's still within the district, they can be moved to another place that will educate them. The district's not required to have that degree of services in every single school. It just wouldn't be practical. And the case law is pretty much clear across the country that, yeah, if you can't go to your home school because you have to be educated elsewhere, and that works conversely. Sometimes the districts will say, oh no, the child can be educated in the home school, and you say, no, this school has got what we need. And so they can move the child around. Again, it's not the location, it's the placement. It's what educational services are being offered, not the actual physical structure. Okay. Yeah.
My daughter, she has multiple disabilities. She's in a public school, and I asked them if I can put her in a private school, and they said no, because she has all the services that she needs at her home school.
Okay.
So what can I do if I want her in a private school?
Well, your first mistake was to ask, because you have certain rights. And that's what, let's get past this idea, and I think, districts sometimes rely on that. That's why they send these letters out that are meaningless. They don't carry all the cards. This is an even playing field. IDEA was drafted and intended to make kids with special needs have equal access to education. So, I'm going to call you on it. Don't ask next time, all right? Say, look, this is the situation. My child isn't getting this. My child isn't getting this. This is what my child needs. You're not providing it. I'd like a private placement. They're going to say no. Your situation is much more difficult than the child being in the private placement. But it depends on how the services are not being, if you go to an IEP meeting and they say, yeah, we'll try this, and they try something and it's not working, and that's documented, and you come to me, I'm going to say, unfortunately, it's not enough. You do it twice, you do it 3 times, the child is having, regression. But the case law says, what the law says, is that under those circumstances, a child cannot regress. And they've tried 3 or 4 different things. Then I feel comfortable going to due process for you, saying, this is the appropriate placement. That's a 2-pronged test I've got to prove. I've got to prove, 1, that the placement that they proposed is inappropriate, and 2, that the private placement you proposed is appropriate. And if I can hit those 2, then you prevail. It's also difficult on that side of the fence, because what ends up happening is stay put is the public school. So while we're litigating, the child remains in the public school. Okay, so it's a tougher battle, but if it's clear that the services aren't being given, that they just don't know how to deal with this type of disability, and I've had that happen frequently. I had a little girl in the northern part of the state who had terrible seizures, and we prevailed. They asked us, we were asking the hearing officer to come here, not only because it's good education, but because it's so close to Hasbro, and we won. That's the other thing, the physical disabilities, if the medical needs are a factor in education, the district has to pay for them. All right, United States Supreme Court has said that when a child has a trach or a vent or oxygen, the maintenance of that equipment is the requirement of the school district. And the reason is because the school district is required to educate the child, and of course if the child can't breathe or can't function, the child can't be educated. And oftentimes they don't have the nursing staff to do that. And depending on the severity of the disability, they will agree, depending on, they're always going to try first, but they're going to eventually agree, depending on how severe the disability is. So, anything else? This was a relatively short one. I was called just not that long ago about it, but it is an important area to understand, because I haven't gotten a lot this year, but last year and the year before, I get a lot of calls that folks are getting these letters, or that they are concerned that their child is going to be taken out of the private placement. The district does not have the unilateral right to pull your child out of a private placement. They just don't. Legally, they cannot do it. So, understand your rights in that regard. Yeah.
Without getting specific or breaking confidentiality,
Sure.
There's a few East Providence families in the room. Is there anything that you can tell us specifically regarding East Providence?
Yeah, I had East Providence last year, and we filed for due process, and they backed off.
How many?
I might have had 4 last year. I kept asking the director of special education to show me the placement, that my clients want to see this placement you have, and there was never a response. So when I filed for due process, I indicated in my due process request that we weren't even able to see the program that they're saying is equivalent to Meeting Street. We filed for due process. Even before we went to resolution, they were resolved. So, it's interesting, because after that, some folks in here will know this, we came to a resolution, let's say of October of 2012, that the children remain in Meeting Street. That was the agreement. What East Providence did was, let's say the next IEP for one of those children was up in November. They'd meet in October and say, okay, you have a 1-month IEP. And no, you can't do that. You have to have annual IEPs. And so I think that was cleared up. But, I mean, they fight you. They fight you. There's no question about it. But, yeah, I had several from East Providence last year, so, you
I
know.
have to listen to rumors, but you hear things and I just don't know.
Yeah. It's terrible, you know, I mean, and I've said this for 25 years. The last job in the world I'd want would be a special ed director, because they're really stuck in the middle. They're required to educate special needs kids, but they're put under the gun with finances. So I don't necessarily blame them. Conversely, parents don't need these letters coming to their house. They don't serve a purpose. They are not letters that are going to, they're basically illegal. I mean, if you want to change the placement of a child because you believe that child could be educated within the district, you sit down with the current IEP team and the parents and say, this is the reasons I think this child can come back into the district, and we think it'll be a good fit. Just this unilateral decision that, hey, your child's going to start on this date in this bus is just, I think as a parent of a special needs kid, it's unacceptable.
I was just going to say, can you explain the process of due process? Exactly what it's like for a parent, like,
Yeah.
you know, if I had to file, like, what do I do? I mean, I understand I file paperwork, but like, you know, I know it doesn't include lawyers and,
It's an evidentiary hearing.
okay.
So there are administrative judges who are lawyers who hear the case. And if you get past resolution, there's a lot of rules. You've got to give all of your exhibits and all of your witnesses 5 days before you start your hearing. You get there, you do an opening statement, you put on your witnesses, you present the law to these hearing officers. The other side does the same thing. They cross-examine the parents. In every case you need an expert, depending on what it is. If it's autism, you need an autism spectrum expert. You've got to have an expert. You also should have an educational expert to say that this particular education is not appropriate and this education is appropriate. There's a lot of putting your ducks in a row before you file, because once you file, it is a fast-track hearing. They move. So you want to make sure your experts are in a row. You want to make sure you have people from the private placement who are willing to testify that we're willing to take this child, that this child will be doing this, and that this child will have an appropriate education. So you got to have all your witnesses, and then the hearing officer within 60 days has to render a decision. If you lose, you have 30 days to appeal to the Federal District Court in Rhode Island, and in that case, they'll take it on. They won't listen to new evidence usually, but they'll take the case on, and in that usually takes 2 years. They're very, very slow there. And then if you lose there, you can go to the First Circuit. So that's generally the process and how it works. And I will tell you, depending on the situation, if you can avoid due process, if you can work it out, and not always you can, but if you can, do it. Because you never know what these hearing officers are going to do, especially if stay put isn't on your side. So that's basically how it works.
You know, as a parent, like, how did we get in contact with, like, a lawyer or someone to represent us?
Well, I mean, there's not a lot of us. When I started this, myself, Amy Tabor, Jeff Mellish, and a couple others, there may maybe 4 of us. I think maybe there's 6 of us now. 20-something years later. And sometimes the Disability Law Center will take them on, but they haven't been taking too many on. So there's some avenues by which you can do it. But what I tell people is I want to look at what you have here, and I give you a recommendation as to whether you should go to due process or not, whether it's likely you would win. It all depends on the situation. The situation I just spoke about, where your child is in a private placement, they truly are. They're the most nerve-wracking, but they're the easiest legally. It's where you're trying to get your child out of a bad public setting into a good private setting that's the toughest. Yeah.
Let me ask a question. So if I get a letter from the district saying that they want to have an IEP meeting or they want me to come, I go to a meeting, sit down, listen to what they have to say, I'm not happy with what they're presenting for services. What do I do at that point?
Well,
Do I say, no, I don't sign anything, or no, I would like this to go to due process? Do I say
No,
that?
don't push due process that early because you're not equipped at that point. First off, if you're sitting down with just their team,
Yep.
I would suggest that I would say at the IEP meeting that this is not the team that should be hearing this. This team doesn't even know this child. If you want an IEP team, we should have it with the team that's educating the child. And the regs indicate that. You know, picking a bunch of people who have read paper and never met this child isn't going to work. Now, if they insist upon that, you can use that at due process. You bring those people in. How many times have you met Johnny? Never. You know, how's Johnny's, you know, certain scores here? I don't know. What does Johnny look like under these circumstances? I don't know. So they sort of hurt themselves by doing that. So that's the first part of it. If during that course of that, they say, no, we're insisting, say, show me your IEP, let me look at it. Never, I shouldn't say never, rarely give a yes or no answer at an IEP meeting. Because you're being given a lot, you're being given a lot of information. And you don't want to make a decision under those circumstances. Here's the IEP, what do you think? No, 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 no. We're not doing it that way. I'll look at this, I'll let you know. Just always do that. Then you have the calm to look at it, to read it, to see, you know, what it does, what it doesn't do. If it's horrific, you'll know that by digesting it, looking at it. If they insist upon it, then yeah, at that point, you're going to have to file for due process.
Okay, so they give me this IEP, I take it from how many days do I have? Do they have a time?
Are you in a private placement setting under this hypothetical?
Say that again?
Is your child in the private placement setting under this
If
hypothetical?
you're in a private placement setting and then you're up at public school.
All right, then you take as much time as you want.
So there's no,
Right.
so many days, like,
No.
let's say I have 10 days, I have to.
No, they're wrong. They're wrong. When these districts say that, that is not true. You do not, you can let them know within 10 days, but you don't have to, that is not, I mean, if the districts looked at the annotations under that regulation, they would see that that is not what the intent of that regulation is. So, but if it takes within 10 days and you want to appease them, say, fine, look, I've made my decision, I'm not interested in this. But don't give them what you want to do. The ball's in their court. They're not going to file for due process, and during that course of that time, your child's still being educated, all right? And it also gives, if you have an attorney, the attorney time to get their ducks in a row to then file. The first thing I do in every case is ask for the child's records, just to see, you know, how the district has been with this particular child over the course of the years, so.
So they all sign it, they say, oh, we recommend it, they say yes, yes, yes. I walk out and say, I'm not sure, I'm gonna look at it.
Yep, then you say no.
Do I never call them back?
No, you do. I mean, you let them know that you're not, let's assume you don't want it, you were part of the team. Well, I've had districts that have said, well, we're going to implement it. And you say, well, right, how are you going to do that?
You do sign it, so they can't.
They can't.
Okay.
They can't. They can't. I mean, they can file for due process, but they can't unilaterally implement an IEP without the team's agreement on it, and you're part of the team.
Because this team has, no one from our team has been to their school.
Well, that's the other factor. I mean, if their team, who hasn't met your child, agrees on it, it's as meaningless as the letter I spoke about. That's just not the way to go for districts, in my opinion. Yeah.
So the last IEP that you sign is whatever is what your child gets,
Right.
no matter what the situation is.
Well, that's the last agreed upon IEP, all right? You no longer have to sign subsequent later IEPs under, you know, but you can agree to it or not agree to it. But what I want to be clear on is if there's a fight over an IEP, and you can't agree on this new IEP, that last IEP kicks in. So if the last IEP is a private placement IEP, that's where the child stays while you fight over this new IEP.
So when you first sign in, they say everything's here. That's just for attendance.
Absolutely.
There's nothing else.
That's exactly correct. It's only for attendance purposes. You can sign that. Yeah.
I have a question. I have two children that are in a public school, and I'm focusing more on my son. He's had an IEP for the last 4 years with the same school. I feel as though they're not giving him the requirements for his needs. I had a lawyer, he had one-on-ones, and the school, like in 4 years, I'm not getting anywhere, so I feel as though my back's against the wall because he's digressing because of his issues that, and they're still not providing what he needs in 4 years.
During the course of those 4 years,
At school, I mean, advocates, lawyers, he was suspended 8 times with an IEP with the one-on-one available to him. I don't understand, so I'm just like, I don't know what else to do.
there's certain, I mean, I can talk to you after, there's certain legal avenues on behavioral components to IEPs and suspensions. There's specific regulations relative to the number of consecutive times a child could be suspended. Have you gone to due process ever?
This is the first time I'm hearing this, so I'm kind of lost because I don't know what
Okay,
that
yeah.
is.
That's,
And I mean, he does have other things besides behavior, he's on medication and things like that.
okay.
other things.
I mean, there's no, right, there's no question he's eligible, he's got an IEP.
Doing what they should. 4
Right.
years in the same school, I've been fighting and pleading and begging, and I'm just like,
Yeah.
stop here.
Yeah, at some point, you're going to have to file for due process, which is what we just talked about. That's, that's the final push. But again, under your circumstances, your child's going to remain in that district until we can win. I
Pretty
know.
much,
Yeah.
that's how I look at it.
Yeah.
Like, who do I call, why do I stop this? So,
Right.
The due process, how do you stop?
The Department of Ed has I would never recommend, this is just me, and I did it when my child was very young, and I'm a lawyer, but I didn't know this law at all. This is how I got involved. I filed for due process, and I was like a deer in the headlights. So I'm more than happy to help people through it, but it's an evidentiary hearing, you need to know the ins and outs of it. Yeah.
These letters that come out, is it safe to say any time in the year that you don't get one? Do they come out at the beginning of the year or at the end of the school year?
Usually.
Because my son, he's actually been in a private setting here since he was
Good.
3.
Okay.
And I've never, ever gotten a letter.
Yeah.
And I've never had a problem.
Right.
I've just jinxed myself. Terrible.
No, depends on the district.
But do they come out at the beginning of the year? Do they come out at any time?
Sometimes they come out in May for next year,
Okay.
which gives them
So
what
once
they,
you start in September, do you consider yourself safe?
depends on when your IEP starts. Your IEP doesn't have to start in September, it just has to be an annual
Oh, okay, so
IEP.
it goes by.
So, my son's here, my son's was always in December, and in December, when the district representative came, at any point, they could have said, okay, we're thinking about changing now. They rarely did. But it depends on the district, definitely. Some districts I deal with on a regular basis, others I've never dealt with.
No, I've never.
Yeah.
I was just going to say, sometimes that conversation, and please, I guess I'm asking you and telling you what we sometimes go through, is sometimes parents aren't getting a letter, but when we're at that annual IEP review meeting, where people think they're just coming in to review the goals, and the district will bring up placement right then and there.
Right, right.
And sometimes we don't even know that that conversation's going to happen.
Right.
So parents at that point still have that same right as if they received a letter.
Absolutely. At that point, in fact, the district is, I mean, I know it sounds more harsh to do it that way, but that is actually the right way to sit at the meeting and say, look, this is what we think. But they can't just say we're bringing the child back at that meeting. They've got to have some substantive basis for it. And then, if they haven't been a part of the educational process, and the law requires them to be, but if they just come to an annual meeting every year and they don't follow the child, they're not going to have the wherewithal to be able to get the child out of the private placement.
I noticed at my son's last IEP, there was more, I noticed there was more questions coming from the district. And I kind of got the feeling that they might be going in that spot, but.
You never know. I mean, sometimes you think that, sometimes it depends on who's there. If
The questions being asked that, like I can feel something.
Yeah, yeah, I know.
Anywhere, but.
I'll make this suggestion as a parent more than an attorney. Don't worry about what hasn't come down the road yet.
Right.
Just don't worry about it. If they raise it, that's when you deal with it. So, yeah.
This may not be the right forum for this, realizing what we have here, but If you have a 504 and you don't yet have an IEP, how do you push for that?
I'm sorry, you don't?
If you have a 504 but you don't have an IEP,
The question will become whether or not your child is eligible under IDEA. And there's the various disabilities and then otherwise impaired. Depending on, if the 504 isn't working and there's been accommodations that have not been working and there's a diagnosis, whatever it may be, and the child is not, the 504 just isn't working for the child, then you go to an IEP, you ask for a meeting to determine eligibility. And you say, look, my child is not working off the 504, we think we need an IEP.
how do you, if they say that the 504 is working and you don't think it is,
You can go to a hearing at the Department of Ed. It's not a due process hearing because you're not in IDEA, but you can still have a hearing on that issue.
and you would engage someone like a disabilities attorney? Like, is that?
Right.
Okay.
Yeah, I've done those cases where I've gotten kids, and districts more and more are pushing against IEP eligibility.
Correct.
They clearly are. And I'm not sure if it's their statistics or what, but over the years I've noticed a big push just on eligibility. And you're going to prevail because what that eligibility generally is pretty much everything on that list, including otherwise impaired. ADHD, ADD is on there, autism spectrum, they're all on there, so.
So, as a real quick follow-up question, if you have a school district that, for example, you have a child with cognitive disorder, and they realize that something like OG would be beneficial to them, but the school district doesn't offer, what they say, we do something similar. But you have a document that says, hey, listen, the child would benefit from OG, from an independent tutor, from a doctor.
Yeah, and
What are your,
it would be that type of a hearing under a 504 where you would have to, the paper doesn't work, you have to bring the OT in and says, look, I work with this child needs OT to stay where the child is during the course of the school day. How much? 2 hours a week, 3 hours, whatever it is. And then you probably would either get your 504 changed, but under that scenario, you're not going to be falling into an IEP because it's just a tweak of the 504 to get the OT in that example. Does that make sense?
Yeah.
Okay. What is a 504? A 504 is when a child needs accommodations in the general education curriculum, all right? A simple example would be moving a child to the front of the class, or a child with Tourette's who needs to be either in the back of the class so they can be out, or in a different type of setting, and you got to accommodate that child. A 504 is a plan by which you can accommodate that child, and that child will still get the proper education. An IEP is, okay, this child has this type of a disability and we need to do a different plan, an individual plan, to educate the child. So it's a completely different plan than a 504. All right, 504, and a lot of the 504 kids go into an IEP at some point in time. Other 504 kids ultimately may not need their accommodations down the road, so it depends on how it works, but that's the difference. Does that?
5-4, so it's just the little steps of getting to the point where they're officially diagnosed as Parkinson's.
Not even. I mean, it may be a diagnosis, it may not be a diagnosis, but it may not be something that affects, that requires an individual education plan. It may be something that just needs to be an accommodation so that they can be educated. I've had kids who've had, who are in wheelchairs, who are fully cognitively fine, who just need 504s, believe it or not, so.
basically says that it guarantees you access to the highway. So for example, education is the highway, it gives you the honor to get.
That's exactly right, whichever route is better. Yeah.
I was told that I feel like they forced me to sign a 504 from the IEP, stating that the IEP is specifically for a lot of academic needs. That's what they had me under the influence of thinking, like, my son doesn't need academic, so he doesn't need the IEP.
That is
They refused, and I'm trying to put his one-on-one in the 504.
He's got a one-on-one?
Yeah, and I had to get a lawyer for them to.
Okay.
But they wouldn't agree on putting the one-on-one in the 504 like it was an IEP. So now,
Right.
he has no one-on-one starting this year because for so many reasons they.
Is it a
It's
50?
just a mess.
All right.
It's crazy. Yeah.
The other aspect of this is that the IEP, the appropriate education, has to meet not only the educational needs of the child, but the emotional needs of the child and the psychological needs of the child. I oftentimes have cases, Asperger's is a perfect example, where the child is educationally beyond on target, very well. But socially is having serious problems. That child's entitled to an IEP. That child's entitled to special educational services that address his social needs. And when those aren't addressed, then you see the academics drop. So they all work together. And trying to get districts to know that and remember that is sometimes difficult. Yeah.
If you're hypothetically presented with a child in private placement, district wants them to bring them in, they actually go through some relatively good steps, getting to know your child, and they offer you a comparable placement. Yet you really don't agree with it, even though it may be relatively comparable, and you insist that your child stays in the private placement. How difficult is it for the child to stay in the private placement in that case?
In that case, you may lose at your due process hearing if it's comparable. You may. The law does want children to be educated within their districts if possible. But you do have the stay put provision to fall back on. So if you don't think, if you're that close, if it's comparable, that may be a situation where resolution or mediation might work out. If you think your child would do okay in that public education setting. Like I said in the beginning, how many of us don't want our child with other kids around the corner in the school or with their siblings? We all do. But we also know when that's right and when that's not right. So if you don't think it's right, you file, stay put remains where stay put is, and then they either back down or you go to hearing on it. That hearing would be a little tougher because it's going to be a comparable education, it sounds like. They don't always take that due diligence, though.
Are there any caveats that you can use for you for that child to stay? What if, for example,
Sure.
it's not an inclusive program?
Right, you mean the public one would not be? Yeah, absolutely. Oftentimes they'll say, we have this comparable program, and it's, at the end of the school building with, 4 other children with disabilities. And how often do they get out? Well, they don't get out. Well, yeah, that would obviously be a major factor in keeping the child in the private placement. And there's a lot of factors like that. You've got to see the program. That would be the first thing I would say, because they're not always comparable. I'm biased. I don't think there's much comparable to this place.
No, great. I'm just looking at it from a different aspect. If it were to be, do we still have a strong case to keep them in private placement?
Yeah. There's always something that I could work with. There's always something I can work with, absolutely. If it's are the teachers certified teachers? Are they, highly qualified teachers now that's required? So there's always something you can work with to try and make your argument. I never go into a due process hearing without something. Even if I tell the parents, look, it looks like we're going to lose, we know we've got 3 or 4 years to fight this, and I've had maybe 2 that have gone all the way to the First Circuit, so.
What is the average expense for a family if they were to file due process, if they got that letter in the mail saying, we want to put your child back in district? What is the average expense to go to due process?
You mean for me?
Well, in general.
Nice way of putting it, yeah.
I cut right to the chase.
Yeah, not like
It depends. It depends on the case. I also agree to a sliding scale, and you should also be aware that if I prevail, then I file with the Federal District Court in Rhode Island for attorney's fees, because I'm the prevailing party. So you get your money back, but it's a bit of a conflict, because oftentimes the districts will say, okay, we'll back off, but we're not paying your attorney's fees. So I've got to sit down with you then and say, look, they're not going to pay for these, but you've won. And, it's an issue sometimes. I can't I can't break down an agreement because of my attorney's fees, if it's in the best interest of the child, so. Anything else?
I have one other question.
Sure.
Do you do much with the local educational advocates in the school systems?
I don't.
Districts themselves?
I've never represented a district in my life. Never. I've been asked to by many, but I won't.
How about local educational advocates, someone who needs to be advocate for the child in the school district? Not for the...
I've never advocated in any capacity for a district, ever. Is that what you're asking?
No.
I'm sorry.
So an LEA is a local educational advocate. So for example, I'm a volunteer parent in my district.
Okay.
And I would go and I would appoint on behalf of the child.
Okay.
in
Yep.
addition. So I'm asking whether or not you put on anything for, there are probably 36 in the state. Probably one in each district.
For,
Seminars and rules and regulations.
no, I haven't. No. I've done, I've gone to various places, but I haven't done that. So. Anything else? Yeah.
I have one more question.
Sure.
This is if they want to change your IEP placement. What in the event that your child is up for a 3-year re-eval, and they say they want to do the testing, the district's going to test your child to determine eligibility?
Absolutely, they have a right.
Then
Well, to
what
determine
rights?
eligibility?
Well, just to continue on with services.
Okay.
Because your child's up for a 3-year re-eval.
Yep.
What rights do we have, and what rights do they have? Do
They have every right to have their evaluations done on that 3 years. They can.
And we can still have...
You can still have them done here, done
Do you have
wherever.
a dual...
Right, you could have,
Evaluation
that's right.
process.
You can. And they have, in fact, they should do it. Not many do it when the child's in private placement, but they can do it.
Like request it and say, well, we looked at the child's needs and this is
Yeah,
what we determined.
they could
based
use
on our
that.
testing results.
Right, they could use that.
And how does that play out in the sense?
It becomes, in the due process, it becomes a battle of the experts, depending on what the disability
A
is.
separate arbitrator might step in and come in and look.
Well, for due process, the due process hearing officer would determine whether or not, the school psychologist or Meeting Street psychologist or whatever made a determination. Sometimes they will appoint their own to make a determination, yeah. But, that doesn't happen very often. At least I don't see it very often. Normally, the 3-year evals are done here, and nobody thinks twice about it. Yeah.
Across six lawyers, that's UNIS and this disability lawyers group.
The Disability Law Center. And I'm trying to think who runs it now. It used to be, well, I know Kate Sherlock's over there. There's some folks over there. I can get you the number. Anything else?
I have just a
Yeah.
basic IEP question, because I wasn't at the first seminar, but at the 3-year evaluation, if my younger daughter, when she was 3, got an autism diagnosis at Bradley, she's done incredibly well. At the school 3-year evaluation, she tested in the normal range. So I was beyond thrilled, but I'm also very leery that, can the school department ever come back and say, we don't think she has autism?
Yeah,
And then,
they have. I've had cases like that.
so she still has an IEP.
Right.
My fear is that, it's going, we're in first grade now, and that's great, she's got support of a special ed teacher, but she's in mainstream, but
Mm-hmm.
I've learned from my other daughter, when 3rd grade hits, it's a whole different dynamic because of the fast pace and.
Yep.
So,
They will come to you in some fashion, or they may, I'm not saying they will, maybe you won't have to deal with it, but if they do, it'll be, their position will be that your child no longer is eligible for IDEA, and that we're more than happy to accommodate her with a 504. And when that happens, you've got to be ready to discuss within that IEP meeting why she continues to need the IEP. You don't see too many of those going to due process, but they do on occasion. Because they're still they're not spending any more money. It's not a change of placement that's going to cost them a lot of money. It's just a designation within the district. And so you don't see that going. Sometimes they'll say, fine, the child can continue to have her IEP, but she'll be educated within the general community or whatever. So you don't see those going to due process too often. All right, yeah.
I have a question. My son has IEP, and we're trying to fight for a reading specialist, but what they give us, they say that because he has an IEP, he can't have a reading specialist.
They say that.
That's what they tell me.
Okay. That's
So
not,
how do I go about fighting this?
well, I would ask them why they say that. Why?
Because he's being serviced by a special ed teacher that is not a reading specialist.
All right, but if he needs a reading specialist, is he having trouble reading?
Yes.
Is he-
Aproxia, he has a learning disorder.
Okay. And he's got an IEP?
Yes.
And does the IEP say that one of his issues is reading?
Yes.
And what is there something in the IEP that's addressing that?
Yeah, that he works with a special ed, that's it.
Yeah, you might want to ask for an IEP meeting. Have you asked for an IEP meeting on the issue?
Coming up.
Yeah, have one, when it comes up, tell him, this special ed person is great, but he's not, and I'm sure you've got some type of data that supports that he's not growing in terms of his reading, or advancing in terms of his reading. Just put that on the table at the IEP meeting. He's not advancing. This is not working. He's got to get somebody who helps him with his reading, whoever that may be.
And what if they say no, then what do I do?
Then you're probably forced to go to a due process, which ultimately, in your case, will end up probably some type of mediation. They bank on a lot of people not going to due process. So if you were to go to due process and you have documents to support the fact that that your child is not reading properly or not reading the way that your child should be reading, then that's a situation that doesn't cost them a great deal of money. They can bring a reading specialist in X number of times, put it in the IEP and call it a day. But unless they know you're going to fight that, they're not going to do it. So, unfortunately, it's part of the battle with being a parent of kids with special needs. You got to fight this fight. And some districts, when you fight, they back off. Other districts, you fight, and they keep fighting, and they keep fighting, and they keep fighting. Other districts don't fight at all. So, it depends on where you live. Yeah.
On my side, I don't know a parent who his child had ADD, ADHD, and all that. I guess he kind of grew out of it, or the drugs and all that. So there was a period, so they took him to come off their IEP. Then when high school came along, I guess that's another, during that age, kind of, they reared his head again. And at that point, he had a lot of difficulty getting help for his son at that point. It's kind of, how do I, so my son's learning, he's progressing. How do I keep him on within the system so that even if the services gets reduced, he's still in the system. So when high school comes, we don't have to go through the whole process. We just have another, it's just another meeting where he needs this, where we can ramp it up.
Because you never know how your child is going to do during the course of their academic time, it's human nature to not give up anything that you already have. Even if you don't need it, you hold on to it because you think you may need it down the road. And that's what you do. And I say that as a parent, not as an attorney. That's what you do. You hold on to it because, they may regress whatever their disability is, and then you at least have that service that you can focus on. So it's easier to keep it than trying to get it back.
Special ed, just for let's say he's got the ESL, but it's just for us it's an extra 15 minutes a day where he's getting one-on-one attention.
Yep.
So
And is he doing?
I see it. how he's growing, I see him really, he's progressing.
Great.
I see him get to the point where they'll start coming to us at the IT meetings, well, he doesn't need this, he doesn't need this, and I see him coming.
If,
I just want us to figure out a way to,
right, generally, in my view, parents see these things coming before the district does, or before educators do. I think they just do because they've known the child better. And you're going to get at IEP meetings, well, we don't see that in school. Well, we don't see that in school. And the child comes home and you see that, or they did so well, look at this, but that's not what they're doing at home. You got to have an IEP meeting, you got to have a frank discussion at that IEP meeting that this child's starting to falter. We see it, we want to catch it before it gets too bad, and these are the things we think are needed. So you got to really be an advocate at that point. If you rely just on the district to see it first, you may never get that call that, hey, something's wrong here.
can't they just say he doesn't need this service anymore?
They can, but they're not, but you can fight that. That's what I'm saying. You know, you can fight it. You can go to due process and say he does need it. And what's even a better case for an attorney is they take it away, you see how bad things go, then you go to due process and say, look how good he was doing. They took this part of the IEP out and now he's really faltering. And a hearing officer will give you that back, most times. Yeah?
We did when my daughter did the one aspect of her IEP anymore, is I had them keep it on there as a consultant.
Sure.
You know, as a
Yeah.
consult basis, so she might not go to speech twice a week anymore, but the speech therapist is on the IEP as a consult, so, and it's the same with the OT, so if I ever see her regressing, that I still have that at least on there, and.
Right. Right. That's a very good way of doing it. Absolutely.
Just as a consult.
Anything else? Yeah.
Why is it so hard to get kids with learning disabilities like dyslexia help in school?
I don't know. It is, though. I mean, it is. It's, I don't know if the districts don't know how to deal with it.
A lot of them don't even recognize it as a diagnosis.
Right. And the ones that are all 504s for the most part that I've seen. And I'm not sure why that is. But it is. It is. I mean, it's too bad. And it's not just that. What's that?
Just hang in there and fight for them.
Yeah. You know. So. Anything else? Yeah.
Hi, my son is in the public school system, and he had IEP. And I didn't know really how to, my rights as a parent, how the system worked.
Yeah.
But I've noticed, in the last, he's 10 years old now, he still can't read, he has a speech thing, and I always, now the last year, I've been, noticing the IEPs, and, there's not, any, enough for him, he's not progressing enough, you know?
Yeah.
People will be like, oh, well, there's only so many services that we can do, you know? So a lot, I'm and to me, they keep passing him along. So it's like he can't read, you're throwing more stuff on him, and he's gonna get more stressed out, you know? So then I was talking to a speech teacher, oh, we're giving him this many days of speech, and I'm like, they were, and this is all, there's nothing else you can, the speech is a big problem, we're not gonna learn how to read unless we get the speech, and they're like, well, that's all we can give him, and then later on I'll hear her say that some other kids are getting more, but then my son is in the low, probably one of the very, very low grade levels in school, so I'm thinking, it just seems like I just keep getting around, the services are not there, or I even asked for a smaller room setting, they're like, oh, we don't have it at this school, and I'm just so I just feel like he's just not making progress, but I keep pushing him.
Right.
And
they, yeah.
wow, and it's
Yeah.
okay, well, then you're not making any progress here.
Right. And sometimes under those circumstances, I'll ask parents to bring me all the previous IEPs, and they're all exactly the same from the previous year. They're almost identical. And so, you really got to advocate and say, look, this isn't happening. And, in some circumstances, you got to file for due process. It might be the only way. Also, it might not, you got to look sometimes a little deeper. It might not be the reading or the speech, but get a neuropsych eval, find out what's going on beneath that.
Yeah, that's how I found out this this coming year. I did a whole neuro to figure out the whole what's going on, just so I can
Right.
share and say, okay, this is what they had diagnosed
Right.
him with, so we need to.
And then bring that to your IEP meeting and say, this isn't about speech. Speech is the symptom. This is about this. And we need somebody to address this.
And I've done that, I had a nervous like anything for me, and I've done it, come, he's been in Bradley, outpatient, I come, all that stuff, and
Still
they
nothing.
still not.
Some of them don't even
Accommodate,
recognize
these
it.
are coming like from doctors, like different accommodations they say that he needs, but the school's just still not.
Not doing it,
providing stuff.
right.
And I'm coming with this stuff.
Right. It sounds like you're at a point where you're just gonna have to file.
Oh, yeah, I just need a number.
Yeah.
Help me.
Yeah.
Something, serious, it's ridiculous.
Anything else? Well, thank you very much. Thank you.